So that's, as I see it, one difficulty with originalism. A second difficulty, in a way an even more severe difficulty, is what you might call the problem of translation. And that is, okay, let's supposing we have a very clear idea of what they were thinking about when they adopted the First Amendment or the Second Amendment or the Fourth Amendment or some other provision of the Constitution. They were adopting that for a very different world. They weren't adopting it for our world. They lived in a different world. And an originalist, I think, has to say, well, okay, that's what they thought about their world, but what does that mean for our world? I don't think there's any way around that problem. So, does the First Amendment apply to movies? Well, you might say, well, of course it applies to movies. Well, why does it apply to movies? Because the original understanding was that it applies to movies? What's a movie, they would have said when they adopted the First Amendment. The Fourth Amendment protects a person's houses, papers, and effects from unreasonable searches and seizures. Are emails papers? Well, not literally papers. Should they be treated as papers? What was the original understanding of that? That's at least on a naive view of original understandings, there was no original understanding about that, of course. Now, these are familiar problems, and originalists have come up with various ways of dealing with them and various quite interesting and creative ways of dealing with them. But I think, at least if you are looking to original intent to decide a case, to decide an issue, these problems are going to be endemic and severe, and they're going to come up not episodically, but pretty much all the time, precisely because of the difficulties of ascertainment. And even when you're not dealing with a dramatic new development like electronic communications, even if you're just dealing with something like the Commerce Clause, the world today looks very different, needless to say, from the world 200 plus years ago. Now, why does this matter? Well, it matters for this reason. Even if people are approaching original intent or original understandings or original public meaning with perfectly good faith, they will be in a position where various different answers to the question, what was the original public meaning, or the other comparable questions, will all seem equally acceptable. And in that situation, either you throw up your hands and you say, I don't know, or you can, sometimes in good faith, the natural tendency is to think, well, gee, the people back then, the people who framed the Constitution, they were smart and thoughtful people. What does a smart and thoughtful person think about this subject? Probably the same thing I think about this subject, being, as I am, a smart and thoughtful person. And the tendency, even in complete good faith, to read your own views, not bad faith, not sort of rigging the game, just in complete good faith, to kind of see what you think is obviously the right answer in the original understandings, given the uncertainty of the original understandings or original public meaning. I think that tendency is severe. Now, sophisticated originalists have come up with various ways of dealing with this. A lot of the ways of dealing with it, though, as I see it, particularly the emphasis on construction as opposed to original public meaning, that where the meaning runs out because it's indeterminate or uncertain, you resort to construction. Well, that's something else. Now you're dealing with precedent, now you're dealing with considerations of policy, now you're dealing with other non-originalist matters. So is precedent a competitor for originalism? I actually don't think it is, because I actually don't think originalism decides cases. I think precedent can decide cases for you. I don't think originalism does in difficult cases. I think what originalism is, and what the function it has served, and it's a valuable function in many ways, is a different one. If you think about the two most influential originalists of the last 100 years, Justice Black and Justice Scalia, if you think about those people, what did they have in common? What they had in common was that they were trying to sweep something away. Justice Black was trying to sweep away the legacy of the pre-New Deal court. Justice Scalia was trying to sweep away, I think as he would see it, certain elements of the legacy of the Warren court. That's what originalism does. It gives you a place to stand when you want to get rid of some precedents, when you don't like the precedents, when you think they are corrupt, when you think they are a misunderstanding of the Constitution. You have to go somewhere, you have to resort to something. So what do you resort to? You resort to the original understandings, you resort to the document itself. Don't take my word for it. You know whose word you should take for it? Martin Luther. This is the basic Protestant understanding. When you're faced with a tradition that you think is corrupt, what do? You go back to the founding, you go back to the origins, and you use that to challenge the tradition. And that is a valuable function, and that's the function originalism serves. But it's essentially a destructive function. It's essentially a way of getting rid of some things. When you want to rebuild, when you want to start building up a doctrine, that's when you resort to precedent. That's when you use precedent. So, I said at the beginning I was going to try to explain why conservatives and advocates of judicial restraint should believe in precedent. Well, essentially that's why. Because originalism is a way of getting rid of things, a way of opening up the field. Precedent is a way of narrowing it down. It narrows your choices. It often doesn't dictate a single choice, at least in cases that reach the higher edges of the appellate system, but it narrows your choices. And that is inherently, that's obviously a reason to think that if you favor judicial restraint, you should believe in precedent. What about conservatism, at least conservatism of the form that is not by definition concerned with conserving the past? Well, here's the thing about conservatism, and it really gets back to the work of the Federalist Society in a lot of ways. In the last generation or so, the law has turned in a direction that's much more appealing to a lot of conservatives. And what you would expect to see is conservatives moving away from originalism. And who will the next wave of originalists be? Well, here's my bet. They're going to be liberals or progressives. That's who the next generation of originalists are going to be, because now they're the ones who want to get rid of things by resorting back to the original understandings. So, Justice Roberts, Justice Alito, don't make very many originalist noises. They're precedent guys. Why are they precedent guys? Think of the system in which they've come of age. They've come of age in a system that was in many ways congenial to conservatives. That's a system they are not trying to overthrow. And as I said to you, my prediction is that what you will see in the next generation is a resurgence of liberal originalism. And as someone who's not, I guess I have to plead guilty to being a liberal, I'm not going to like liberal originalism either, and neither should you. Thank you very much.